Welcome to the Law Offices of Chris M. Ingram podcast. We are continuing our discussion on love and marriage between American citizens and their foreign partners, and how to legally bring these partners into the U.S. the right way. Let's dive into part 2 of this 4-part series. Before we get started, we would like to acknowledge attorney Chris Ingram and his dedicated legal team. They did a great job researching and preparing this material for us. We are thrilled to be able to present this topic for you today. Okay, let's unpack this. In our previous deep dive, we sort of introduced the K-1 Fiancé Visa, that crucial pathway for American citizens wanting to bring their foreign partners here to the U.S. for marriage. Specifically, it all hinges on that critical 90-day window, right? The time frame they have to actually get married once their partner arrives. We touched on the rise of international romance, which is fascinating in itself, and the huge significance of that strict 90-day deadline, plus the absolutely vital role reputable legal counsel plays. It's complex. We even looked at that case study, Sarah and Juan, remember? Just to show how having an experienced attorney, how it can really smooth things out, avoid heartbreak.
Yeah, what's really fascinating there is just how smoothly it can go when it's well-guided. It turns this potential bureaucratic nightmare into something manageable. That case, Sarah and Juan, really highlighted the ideal scenario, didn't it? When everything's handled precisely from day one. But today, connecting this to the bigger picture, we're going to really dissect the K-1 process itself, step by meticulous step, get into the real nitty-gritty. And then, crucially, we'll dive deep into those often overlooked challenges, the ones fiancés face when they actually get to a U.S. port of entry. See, a lot of people think that's just a rubber stamp. Visa approved, you're in. But nope. That's actually where many couples hit unexpected hurdles, even with an approved visa. It just underscores the absolute need for precision, for preparation at every single stage. From the first form to that final chat with the CBP officer, we'll show you why even seemingly small mistakes or just not fully understanding the process can trigger big delays, or worse, outright denials. And that costs couples not just money, but time, precious time, and huge emotional energy.
That's such a powerful point. The journey isn't really over until you're truly, truly across that finish line. Our legal team, they've meticulously outlined this K-1 process into several key stages. And when you look at it laid out, it's clear. Each stage needs incredible precision. You've got to be careful to avoid those dreaded delays, those denials that just throw everything off track. So we're going to walk you through each one so you understand exactly what to expect from the moment you decide, okay, this is the path, right up until you're finally together, married, in the U.S. It's quite a journey. Lots of checkpoints.
Exactly. Think of it like a detailed roadmap, or maybe a carefully crafted blueprint for your future together. Every turn, every checkpoint, every single piece of paper, it matters hugely. If you underestimate the importance of any one requirement, you could derail the whole thing, which is why understanding this full sequence is just paramount. And our attorneys, they often tell us the devil is truly in the details when it comes to immigration law. It really is.
Okay, so stage 1, it all begins with the U.S. citizen taking that first big step. That's where it kicks off, right? What exactly does that involve?
Correct. Yeah, the U.S. citizen files a petition. It's called Form I-129F, Petition for Alien Fiancé. And they file it with USCIS, it's U.S. Citizenship and Immigration Services. Now, this isn't just, filling in names and dates on a simple form, not at all. It's really about providing robust, compelling evidence, proof, to show USCIS that you have a genuine, legitimate relationship that meets their pretty strict criteria. And the insight here is crucial. USCIS isn't just looking for proof you're in love. They need evidence of a documented, sustained, shared life. You follow. Think of your evidence like building an undeniable timeline of your relationship. Not just a few nice photos, we're talking tangible proof. Things like shared photos, yes, but from different stages. A comprehensive collection showing you together over time, maybe with family, at events. And detailed, extensive chat logs, WhatsApp texts, whatever, showing regular heartfelt communication over a significant period. Our legal team actually advises clients to provide screenshots, highlighting dates, times, even specific messages that show the depth of your connection. Then there's the travel stuff. Meticulously documented travel records. Flight itineraries, boarding passes, passport stamps, even hotel receipts. Proof you've met in person within the last 2 years, that's a key K-1 rule. Sometimes it's the small, consistent details. Shared bills for trips, maybe joint gifts, even letters from friends or family who can vouch for you. Those often speak louder than grand gestures. The goal, the whole point, is to thoroughly convince the immigration authorities this is real, this is bona fide, meaning it's genuinely based on shared life, mutual commitment, a clear plan to build a future. Not just, a way to get around immigration laws, because any incomplete evidence, or if the proof just isn't persuasive enough at this initial stage, it can, and often does, lead to what's called a request for evidence. An RFE. Think of an RFE like USCIS hitting a massive pause button on your whole application. They're basically saying, hold on, we need more info before we can move forward. It's not a denial, not yet, but it's a big hurdle. An RFE can easily add months, sometimes even longer, to your wait time while you scramble to get them what they need. It completely messes up your timeline, causes immense stress. Our attorneys always say investing time in a thorough initial petition saves so much time and anxiety later. It really does.
Okay, so USCIS gives the initial nod. They say, all right, this looks like a genuine relationship. It qualifies. What's next for the foreign partner? Does the petition just get sent straight to the embassy, or is there like another step in between?
That's a great question, and it's often a point of confusion. So after USCIS approves the petition, it doesn't just sit there, and it doesn't go straight to the embassy either. Instead, the approved petition goes to the National Visa Center, the NVC. Think of them as like a central administrative hub. Their really crucial job is to make sure all the pre-interview paperwork is collected and checked before the case even gets to the U.S. Embassy or consulate. This step is vital. It prevents delays later by making sure all that preliminary stuff is in order first. The NVC assigns a case number, then sends instructions to the foreign fiancé, usually about paying fees and submitting more documents, civil documents mainly. Once the NVC has processed all that, then the case gets sent on to the U.S. Embassy or consulate in the foreign fiancé's home country. And that's where the consulate processing stage really kicks in. The foreign fiancé applies for the actual K-1 visa there at that embassy or consulate. This stage involves giving biometrics, fingerprints, photos for background checks and ID verification. Plus, they have to submit a whole host of other documents.
Police certificates from everywhere they've lived for a certain time, birth certificate, divorce papers if they were married before, and critically, proof of financial support from the U.S. citizen. That's usually Form I-134, the Affidavit of Support. This whole part is their first direct face-to-face interaction with U.S. officials overseas. It's a big information gathering phase for the embassy before the interview, so the insight. The NVC is like this unseen but really important gatekeepers for the interview. If you don't clear the NVC hurdles, your case won't even reach the embassy stage.
Right. And I understand there's also this mandatory health part during this phase, no matter where the partner is from. Sounds pretty crucial for everyone involved. What's that about?
Absolutely. It's totally indispensable. It's about public health and safety, for the U.S., but also for the person coming in. An approved doctor, one specifically designated and vetted by the U.S. Embassy, has to do a thorough health check on the foreign fiancé. And this isn't just a quick look over. It's a comprehensive medical screening. It's specifically designed to find any communicable diseases, things of public health significance like TB, or certain conditions that could make someone inadmissible, meaning they can't enter the U.S. They also check vaccination records rigorously, making sure they meet U.S. health standards. It's a non-negotiable step. Got to meet all health requirements before a visa can be issued, period. Without that clean bill of health from the authorized doctor, the process just stops. It can't move forward. And that medical exam is usually only valid for 6 months. So timing can be really important there too. If they find something unexpected, it can cause major delays. So yeah, being proactive about your health history can definitely help.
Okay, now this sounds like the really big moment for the foreign partner. The culmination of all that paperwork, all that waiting, the visa interview. Is it as high stakes as it sounds? What's the key thing for the applicant to know here?
It often is, yeah. And it can definitely feel incredibly high stakes, understandably so. The fiancé goes for a personal interview at the U.S. Embassy or consulate. And this is where clarity, consistency, and frankly, confidence are just paramount. The key insight, I think, is that the consular officer isn't just verifying your story. They're cross-referencing every single word you say against every single document you've ever submitted. Consistency is king. Any deviation, even if you're just nervous and stumble over a detail, can trigger a red flag. They might think you're misrepresenting something. During the interview, the officer will ask detailed, sometimes quite probing questions about the relationship itself, how you met, where, how it developed, shared experiences, future plans. They'll definitely dig into the wedding plans. They want concrete details, like where's the ceremony, when, who's coming, what life do you picture together. They might ask about your fiancé's family, their job, your favorite shared memory, anything really. And critically, they will probe your long-term immigration intentions. Any inconsistencies between the petition, the documents, and what you say in the interview, well, that raises serious red flags. It can lead to long delays, or even an outright denial. Our legal team always stresses this. Preparing for the interview, maybe with coaching, mock questions, it's just as vital as getting the documents right. Knowing what to expect, how to tell your story truthfully and clearly, having that consistent narrative, it can make all the difference. approval versus denial. We've seen genuine couples, just unprepared for the interview's intensity, give vague answers and run into problems. It's tough.
You finally got your family together on a H-1B. Your American dream begins. Your employer files for your EB-2 green card, but the wait is over 11 years. As the years go by, frustration grows, and now the company is talking about layoffs. This could be the end of your American dream. You search for help, but luckily, you land on breakthroughusa.com. They listen, reassured you, and built your EB-1 case with precision. Then one day, a notification buzzes, EB-1 approved. With your EB-1 green card, your entire family can breathe.
I have got my visa. I got my visa.
That's why the law offices of Chris M. Ingram is trusted. Your future shouldn't wait. Let's talk EB-1.
What are the next steps?
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
Wow. Okay, so let's say they nailed the interview. The visa is finally approved. After all those stages, the medical, the interview, it must feel like, okay, time to pack the bags, book the flight. The finish line's right there, yeah. But you hinted earlier, there's still another checkpoint.
Not quite there yet. And this is such a common misunderstanding. It really catches people off guard, turning what they think is the final step into, well, another significant challenge. Even with that approved visa stamped to the passport, this is where many get surprised. They mistakenly think entry is guaranteed. The key insight here: the visa is just permission to seek entry. It's not an ironclad guarantee you'll get in. At the U.S. Port of Entry, could be JFK Airport, could be a land border protection. It's the Customs and Border Protection officers, the CBP officers, who have the final say on admission. They aren't just stamping passports. They're doing their own independent assessment right there, right then. They will verify the visa's purpose through more questions, sometimes quite extensive questioning, and a careful review of your documents. This isn't just a formality. It's a critical security check, a compliance check. Even with that approved K-1 visa, final entry is still totally at their discretion. They're looking to make sure nothing significant has changed since the visa was issued, that the person is still admissible under U.S. law.
And crucially, that their intentions perfectly match the K-1 visa's purpose, which is specifically to marry their U.S. citizen petitioner within 90 days. It's another critical checkpoint where being prepared really pays off. It can prevent a truly devastating outcome, like being refused entry right at the gate. We'll definitely get more into this gauntlet at the border soon because it's often the most surprising hurdle for couples.
Right. And finally, let's say they successfully navigate that port of entry, get past those final checks. What's the very last, and you could argue most important step in this whole K-1 journey? That clock must be ticking loudly now, right?
Absolutely. The second your fiancé sets foot on U.S. soil, that 90-day clock starts ticking immediately. No exceptions. The K-1 visa is granted for one very specific, very strict purpose: to allow the foreign fiancé to enter the U.S. solely to marry the U.S. citizen who petitioned for them. So the couple absolutely positively must get married within 90 days of the foreign fiancé's entry. There are zero extensions to this 90-day period. Zero. It's not just a deadline. It's really the make or break moment for their entire immigration status based on that K-1 entry. Then, after the wedding, the foreign spouse applies to adjust their status. They go from being a K-1 visa holder to applying for permanent residency, getting a green card. This means filing another form, Form I-485, application to register permanent residence or adjust status, plus more supporting documents. Proof of the marriage to the certificate, sure, but also things like joint bank accounts, maybe a shared lease, photos from the wedding, evidence you're building a life together. If for whatever reason that marriage doesn't happen within those 90 days, the K-1 visa holder falls out of status immediately. And that can lead to severe immigration consequences like potential removal proceedings, deportation, and long-term bars from getting future immigration benefits. It's serious. It's a super strict deadline designed to ensure the integrity, the legitimacy of the K-1 program. So the insight: the K-1 visa itself is really just chapter one, the marriage within 90 days, and then applying for adjustment of status. Those are the crucial next chapters that lead to long-term residency in the U.S.
Okay, so your fiancé has the K-1 visa, cleared the embassy interview, passed the medical, gone through all those rigorous steps we talked about. But like you said, the journey is not quite done until they're successfully through that final checkpoint at the U.S. port of entry. It really sounds like even with that approved visa, you're not truly in until you've satisfied CBP. But isn't that a bit redundant? Haven't they already done all the checks and interviews? What exactly are these CBP officers looking for? What kind of questions are they asking right there at the border?
Yeah, that's a really common and totally understandable question. Lots of people assume that CBP inspection is just, a formality, a quick stamp. But it's far from it. You have to think of CBP officers at the port of entry as the final line of defense. For national security, yes, but also for immigration integrity. While USCIS handles the petition and the State Department, through the embassies, issues the visa, CBP has the ultimate authority to admit or deny entry. The final word. Their job is to make sure that the person standing there with the K-1 visa is, in fact, the legitimate fiancé of a U.S. citizen, and that they fully intend to marry within that 90-day window. And, crucially, that no new reasons have popped up since the visa was issued that would make them inadmissible. They're essentially re-verifying everything, all the information provided throughout the entire process, looking for inconsistencies, changes in circumstances, any red flags that might have been missed earlier or maybe just developed since the approval. Think of it as a final, critical layer of review before someone is allowed into the country. And you can expect the questions to be direct, pretty probing sometimes. Often, they mirror the questions from the consular interview, but maybe with a sharper focus on immediate intent. For instance, they'll almost certainly ask, how and where did you meet your fiancé? And they'll want specifics, not just online or on vacation. Details about the circumstances, the date, how things progressed. They might ask about the proposal again, or the last time you physically saw your U.S. fiancé, another really common one. What are your wedding plans? And here, they need concrete details. It shows you have a genuine, immediate intention to marry. So, knowing the proposed date, the venue, maybe who's attending, any arrangements you've already made, like booking a caterer or buying a dress, that helps. And critically, this question often trips people up. Do you plan to stay in the U.S. permanently? This is checking your long-term intent. The correct answer has to align with the K-1 visa's purpose. Something like, yes, I plan to marry my U.S. citizen fiancé within 90 days and then apply for permanent residency. If you just say, no, I'm just here to visit, or I'm not sure, that's a huge red flag. It signals you might not understand the visa's strict purpose.
That makes perfect sense. So with that level of scrutiny, what usually leads to a smooth entry? What should people listening really keep in mind as they get ready for that final conversation with CBP?
Well, our attorneys consistently find that applicants who are well prepared, whose answers are consistent, totally aligning with the petition, the embassy interview, the documents they're carrying, they usually get through smoothly. And having robust, easily accessible documentation is key too. That consistency across all stages, it's just vital. It signals authenticity, transparency. It shows your story, your intentions. They're genuine and haven't changed. It's so important to have your key documents organized and ready to hand over, not buried deep in your suitcase somewhere. Things like copies of the approved I-129F petition, the original K-1 visa in your passport, of course, the sealed medical exam results if they didn't take them at the embassy, your original birth certificate, and especially any recent proof of your relationship or wedding plans. Think wedding invitations, maybe a contract with the venue, the receipt for the engagement ring, updated photos together, recent chat logs. Even just having a simple, neat folder with these key documents clearly labeled can seriously speed things up and prevent unnecessary suspicion. And being calm, honest, direct in your responses, that's essential too. Trying to be evasive or giving really short answers can definitely be interpreted negatively.
Okay, on the flip side then, what are the warning signs? The things that could immediately raise a red flag for a CBP officer and potentially lead to someone being turned away. Right there at the airport. This sounds like where the stakes are just incredibly high.
Yeah, they really are. There are several critical red flags that CBP officers are specifically trained to spot. And any one of them could lead to refusal of entry, which is just devastating. These include any prior visa overstays. If someone came to the U.S. before, maybe on a tourist visa, and stayed longer than they were allowed. That immediately signals a history of noncompliance with U.S. immigration law. It raises serious questions about their true intent now and their likelihood of complying in the future. Big red flag. Also, vague or hesitant answers about the relationship, about the future plans. That's deeply concerning to officers. They need clear, confident answers that show a genuine, well-thought-out plan for marriage and life in the U.S. If the answers don't quite match the documents or what was said at the embassy, it creates significant doubt. And insufficient supporting evidence. Even if the visa was approved months ago, CBP can still ask for more proof at the border if they have concerns. If the applicant can't provide it right then and there, that could lead to refusal. Which brings up that important question: what if things have legitimately changed since the petition was filed? Maybe the wedding date shifted. Well, that needs to be addressed transparently. Ideally, you'd have new documents to support the change. Otherwise, it can look suspicious. Becomes another red flag. Any hint of misrepresentation or fraud is taken extremely seriously.
That makes sense. It's all about ensuring everything lines up perfectly, no surprises. But does where someone comes from play a role? Their nationality? Is it fair to say some people might face a tougher time at the border, even with a valid K-1 visa?
Unfortunately, yes. It often does play a role. Applicants from countries that the U.S. government labels as high fraud or geopolitically sensitive might face tougher, more detailed questioning at the port of entry, even with an approved visa. Now, this isn't supposed to be about discrimination against individuals. It's framed as risk assessment, based on past patterns of visa fraud or security concerns historically linked to certain regions. For example, our attorneys often see applicants from places like, say, Nigeria or Syria countries with historically higher rates of immigration fraud, or maybe experiencing significant geopolitical issues. They might undergo more thorough secondary inspections. That means they get pulled aside, taken to another room for much more in-depth questioning, more document review. It can take hours. For these individuals, meticulous preparation isn't just recommended. It's absolutely essential. Non-negotiable. It means having every possible document, every chat log, every photo, every travel receipt, every email perfectly clear, organized, ready to show. They need to be able to articulate every single detail of their relationship and future plans with total clarity and consistency. Basically, anticipate being under a microscope. It puts a much greater burden of proof on them. They need an undeniable demonstration of legitimate intent. So the lesson: over-prepare, regardless of where you're from, but especially if you're coming from a region that might attract extra scrutiny.
Rome, 20,000 spectators, one epic battle, 2 warriors, one destiny. But before they can fight for glory, they must face the real challenge, getting their visa approved.
If you want to enter, show me your visa.
They should have went to the law offices of Chris M. Ingram. They are very good.
Yes, I've heard the same. They handled my visa in no time.
They are not approved! They are not approved! They are not approved!
Off to the Lions pit!
Come with me, boys. It's dinner time.
Because even legends need the offices of Chris M. Ingram.
Are you looking for a visa? Why don't you get your free consultation on the Breakthrough website? We're with you every step of the way.
Wow. Okay, let's bring all this theory to life now with a really powerful, real story. This one comes from attorney Chris Ingram's files. In this case, it highlights exactly the dangers we've been talking about, particularly the huge cost of relying on non-accredited services, trying to cut corners on something this important. It's the story of Emily and Aid. And it really drives home how seemingly small choices can have massive life-altering consequences.
Yeah, this case is such a stark reminder what looks like saving money up front. It can lead to far, far greater expenses down the line, both financially and, maybe even more importantly, emotionally. It's a real cautionary tale. It illustrates just how critical it is to have expert, legitimate guidance when you're dealing with something as complex and sensitive as U.S. immigration.
So tell us about Emily and Aid. How did their story start? What made their connections seem so real?
Well, Emily was a 29-year-old nurse from Cleveland, Ohio. Aid, a 27-year-old engineering student from Lagos, Nigeria. They met back in 2023. Emily was on a medical volunteer trip in Abuja. Their bond formed really quickly and deeply. They spent late nights talking in this bustling refugee clinic where they were both helping out, sharing stories, dreams. Aid's optimism, even in tough circumstances, and his vibrant stories about growing up in Lagos, they really captivated Emily. Their connection felt instant, strong. After Emily went back to Ohio, they worked hard at the long-distance thing, daily Zoom calls, thousands of WhatsApp messages back and forth. And Emily made 2 dedicated trips back to Nigeria. She didn't just visit Aid. She really immersed herself in his life. Met his parents, his siblings, shared meals, became part of his family. That really showed their commitment. Then in 2024, during Emily's second visit, Aid proposed. It was apparently very romantic, under a mango tree in his family's compound, with a ring he'd saved up for months to buy. They were planning an Ohio wedding, dreaming about finally starting their life together. From everything our team could see, this sounded like a genuinely strong, well-established relationship. Exactly the kind the K-1 visa is meant for. They'd done everything right, personally speaking.
So, a beautiful, genuine connection, a solid foundation. Given all that, where did things start to go wrong for them with the immigration process? It sounds like they had everything going for them.
Well, despite the strength of their personal bond, this is exactly where the critical misstep happened. Trying to save money. Emily looked online for help with the K-1 visa, and unfortunately she found one of those online visa services. It advertised K-1 assistance for what seemed like a bargain, only $500, which was, way less than the $3,000 or so that licensed attorneys she'd looked into were quoting. The service's website looked really polished, professional, even had these glowing client testimonials. Seemed totally trustworthy. But, and this is the absolute crucial point for you, our listener, it was not a licensed law firm, not run by attorneys. This is where the huge red flags should have gone up immediately. They were essentially just a document preparation service, not providing legal counsel. And that distinction, it's paramount when you're navigating complex immigration law. It's the difference between someone just helping you fill out a form versus someone giving strategic legal advice and actually representing you. Big difference.
That point about appearances being deceiving is so critical, isn't it? Especially when the stakes are this high. So how exactly did using the service lead to problems? What specific errors were made?
Precisely. And the consequences of that fatal flaw, choosing the cheap, unlicensed service, they became apparent really quickly. The service submitted just a minimal petition to USCIS. Bare bones. Like just a few generic photos and a single one-page summary of their relationship. That was it. They left out absolutely crucial, compelling evidence, stuff that would have proven Emily and Aid's relationship was real. Things like Emily's detailed travel receipts showing her trips to Nigeria, Aid's official university transcripts proving his student status and ties to Nigeria. And maybe most importantly, their extensive, deeply personal 2000-message WhatsApp history. That proved the depth, the consistency, the genuine nature of their daily communication. Leaving all that out, it was catastrophic, like trying to build a house with no foundation, just doomed from the start. So predictably, because of this glaring lack of proof, USCIS issued a request for evidence, an RFE, citing insufficient proof of a bona fide relationship. This happens all the time with poorly prepared petitions. Our legal team knows exactly what USCIS needs to see to avoid this. The service, how did they respond to the RFE? With a generic, templated letter. It did almost nothing to address the government's specific concerns or provide the missing documents, which basically left Emily and Aunt Aid completely overwhelmed and totally unprepared to deal with the government's serious doubts about their relationship. They were essentially abandoned, left to figure out a complex legal problem on their own.
And then came the interview. I imagine things only got worse there, especially with Irud being from Nigeria, which you mentioned can face tougher scrutiny anyway.
You're absolutely right. The situation just spiraled downwards at Aid's consular interview in Lagos. This was early 2024. The consular officer, already knowing Nigeria has a high fraud profile, scrutinized their 18-month courtship with extreme skepticism. Questioned if it was long enough, despite their deep connection. The officer even probed their religious differences, Emily being Catholic, Aid Muslim. Now, that's not a direct reason for denial, but sometimes officers look at things like that as potential red flags if they're already skeptical. Searching for reasons to doubt, maybe? And because that unlicensed service had provided zero coaching, zero preparation for the interview, Aid was nervous. His answers about how they met, their relationship, their future plans, they came across as inconsistent, sometimes vague. And that led directly to a visa denial. Just like that, a crushing blow. And the truly tragic part, it was entirely preventable with proper guidance, proper preparation. The couple was just devastated. Dreams shattered. They spent months apart, going through immense emotional strain, uncertainty. That initial $500 they paid the unlicensed service, completely wasted. And their savings got drained, further dealing with the aftermath, trying desperately to figure out what went wrong. Which brings us back to that important question. Was that initial saving of, $2,500 by choosing the cheap service really a saving at all? When it resulted in a denial, a year of wasted time, significant emotional distress, and ultimately needing to spend much more? The answer is obviously no. That single decision cost them precious time together, their peace of mind, and in the end, way more money.
That's truly heartbreaking. Just awful. How did they even begin to recover from that? It sounds like they were at rock bottom, not just financially, but emotionally too.
Thankfully, yeah. A colleague of Emily's, seeing how distraught they were and hearing their story, referred them to a licensed attorney, a real immigration attorney. And this was the absolute critical turning point. This attorney, who specialized in K-1 visas, immediately dug in and uncovered the whole mess. The list of critical errors made by that unlicensed service. They found missing affidavits. Sworn statements from friends and family who could personally vouch for the relationship, give firsthand accounts of their genuine bond. Completely overlooked. They discovered untranslated love letters written in Yoruba. Vital cultural proof of Aid's genuine affection. His commitment. Totally ignored by the first service. And a crucial technical detail. The initial financial sponsorship form, the I-134, meant to show Aid wouldn't need public assistance. It was incomplete, filed incorrectly. These were all huge oversights. Things an experienced, legitimate legal team would have spotted and fixed right from the start. So the attorney didn't just try to patch up the old application. No way, they refiled. A completely new, comprehensive, meticulously organized petition. It was 350 pages long this time. This new submission, it included everything. Painstakingly translated WhatsApp messages showing their deep daily connection over months. A wealth of high-quality photos from Emily's Nigeria trips, clearly showing them interacting with family, friends, real-life stuff. Even a heartwarming video of Addie's proposal under that mango tree. Plus, crucial affidavits from Addie's university professors, from Emily's co-workers, all corroborating the relationship, its genuineness, how it progressed. This wasn't just a pile of papers. It was a complete, compelling narrative, built on undeniable evidence, telling their story in a way that left zero room for doubt. It's like the difference between a flimsy one-page resume and a fully detailed, compelling professional portfolio proving your qualifications.
Wow, 350 pages. That's a massive difference in approach. And what was the outcome after all that significant effort and, frankly, additional investment?
Well, it was still a long road. It took time to undo the damage. But the outcome, ultimately, was successful, thank goodness. After about a year of diligent work by the attorney appeals, persistent follow-up, and an additional $6,000 in legitimate legal fees. Now remember that initial $500 saving. It turned into a total cost of $6,500 plus a year of heartache, separation. Just awful. But finally, Beatty's visa was approved in June 2025. This case perfectly illustrates it, doesn't it? Investing in proper professional legal guidance right from the start, or at least early on if you hit a snag, it can save immense time, prevent overwhelming emotional distress, and ironically, it can ultimately save you a significant amount of money in the long run. By avoiding those costly errors, avoiding repeated applications, it's really an investment in a successful future, in your peace of mind, not just a gamble on a cheap service.
So after that whole terrible ordeal, Allende finally had the visa. Was his entry into the U.S. finally smooth sailing after navigating such a difficult path, or were there still some final hurdles at the port of entry?
Well, even with the approved visa, and despite all the extensive preparation attorney Chris Ingram's legal team had done this time, there was still that final hurdle, the Chicago port of entry. As we discussed, it's standard practice. CBP officers questioned Aid about his intentions. Why was he entering? What were his plans? But this time, it was different. The attorney's comprehensive packet, which included tangible proof like the wedding venue contract, the receipt for the engagement ring, updated photos, even a detailed itinerary for upcoming family events Emily had planned, it was all right there, immediately available. And that ensured Aid's entry without any further issue. He was prepared for every question. His answers were totally consistent with the rock-solid documentation he carried. It was just a testament to how thorough preparation is the ultimate key, especially at that final checkpoint. So with that final barrier finally overcome, Emily and Aid were able to get married. They had a joyful ceremony in Cleveland in August 2025, surrounded by about 70 guests who had supported them through that incredibly arduous journey, celebrating their hard-won union. Their incredibly tough ordeal, though. It served as a powerful, albeit really painful, lesson for them. It underscored the profound dangers of relying on those non-accredited services, and how what looks like cost-cutting up front can lead to devastatingly costly, painful, emotionally draining setbacks down the line. It really reinforced that when you're dealing with your future, your family's future, expertise truly matters.
So, what does all this mean for you, our listener? Emily and Aid's story is such a vivid, real-world example. It shows why diligence, thoroughness, and getting the right legal expertise from a licensed attorney are just absolutely paramount, especially when you're navigating complex, sensitive immigration paths like the K-1 visa. It's clearly not just about filling out forms correctly. It's about strategically presenting your case, proactively addressing potential challenges, making sure every single detail aligns perfectly with what immigration requires.
Indeed. And think about how much more than just money was lost in Emily and Aid's initial mistake. That precious time they spent apart, feeling helpless, frustrated. Just imagine the emotional strain on their relationship, constantly worrying, fearing their dream might never happen, the sheer uncertainty that just hung over their lives for over a year, the cost of getting it wrong. It goes so far beyond the legal fees. It impacts lives, dreams, the very fabric of your relationship. And this is precisely why thoroughness, meticulous preparation, and getting professional guidance from a legitimate legal team right from the start isn't just valuable, it's truly invaluable. It's an investment in your peace of mind and in the successful realization of your future together. That's a critical takeaway for anyone even considering this journey. Choose very, very wisely who you trust with these incredibly important plans.
Absolutely. Well said. And that's a perfect lead-in to our next session. We've certainly done a deep dive today, haven't we? Into the intricate stages of the K-1 visa process, those critical challenges at the port of entry. And the story of Emily and Adi, thanks to our research team, really brings it all home. In part 3 of this series, we'll explore even more country-specific challenges, particularly for applicants coming from regions considered high risk. We'll see how focused legal expertise can strategically address those unique hurdles, building on what we learned today from Adi's experience. We'll also dive into another fascinating case study. This time, it features a couple who overcame really intense scrutiny surrounding their Chinese-American relationship, and they do it through truly strategic preparation and proactive legal planning. So join us next time to learn even more about navigating those geopolitical complexities and ensuring a successful K-1 visa journey, even when the odds seem stacked against you. What might look like insurmountable obstacles can often be overcome with the right strategy, the right guidance. Thank you so much for being with us today. We hope you gained a lot from this discussion. Once again, we would like to thank Attorney Chris Ingram and his team for researching and preparing this material for our presentation today. They are doing an awesome job. Please leave us a comment if you can, as it really means a lot to all the staff. If you would like to book a free consultation, please visit www.breakthroughusa.com. See you next time on Let's Talk U.S. Immigration. Bye for now.